Hello and good afternoon to one and all present here. It is my honor and privilege to be hosting this webinar on behalf of the placement cell for all of you there. We have with us today Mr. Robin David, who would be addressing our students on the career opportunities in the field of alternative dispute resolution. And on behalf of the management, students, and everyone, I welcome you, sir. I would like to now invite my colleague, Nilani, to please introduce our speaker for the day.
Good afternoon. Our speaker for the day, Mr. Robin David, is currently a partner at Dua Associates, Delhi. Mr. Robin specializes in civil and commercial dispute resolution. Sir has worked extensively on matters relating to corporate laws, mining law, anti-corruption laws, and arbitration. Sir also serves as a governing council member of the Indian Council of Arbitration and a registered foreign lawyer of the Singapore International Council Court. He played a key role in drafting the National Highway Fee, Determination of Rates and Collection Rules 2008. Not to mention, Sir is also a part of the Jesuit family. He holds a degree in physics from Loyola College, Chennai. Thank you. It's an honor to have you over, sir. Over to you.
Thank you. Thank you. So how do we start, in the sense it's going to be interactive, and how do questions come? How will you be taking questions?
So you can ask the questions and the participants can either answer on the chat box, or if they would like to interact, they can also raise their hands. Students who are watching over YouTube will just respond on the YouTube comment box.
Okay, okay.
Yes,
so can I have share screen?
Yes, sir. So I think you should be able to share your screen now.
Yes, can you all see this?
Yes.
Yes, sir, your screen is visible.
Okay, if you can tell me on the chat box quickly, what is, many of you have done internships. I believe you're all in the 5th year of law school. So many of you would have done internships. So what, in your view, is dispute resolution? Because firstly, we should know what is dispute resolution, and then what is alternate to dispute resolution. So anyone can put it on the chat box so that I'll have a quick view of your thoughts. Okay, somebody, Andrew says dispute resolution is between two parties where they try to find a solution. Quite right, Andrew. Anyone else? So I'll just start off. There are different types of resolutions under the common law system that we follow in India and in many parts of the world. We have both the, we have an adversarial system in countries like South America, certain countries from South America, European countries, they follow the civil law system. So in the adversarial system, the parties are pitted against each other, and the lawyers adduce evidence. The lawyers decide which kind of documents are to be filed in the court. The lawyers decide what is the best evidence and what is the best evidence to prove. And there is examination and cross-examination of witnesses. However, in the civil law system, the judge has an what is called an inquisitorial role. And in this role, the judge gets to sometimes examine who the witness is, etc. Decide which are the documents, decides what is the best evidence. So the role of the advocates is much higher in our system that we follow in our country, in most of the common law countries. So the parties are pitted against each other, and it is right versus wrong. Like you're supposed to prove, for example, in an arbitration or in a civil suit, if a statement is made, then the opposite party denies it, and it's on the onus is on the plaintiff to prove a certain fact or a point of law. So that's why it is adversarial. So there's A against B. So there's a right and a wrong. And sometimes in the adversarial system, it depends on how well the lawyer performs or how well the evidence is placed in court. Therefore, sometimes a good lawyer can win a bad case. And also in the adversarial system, a case can be lost because of poor evidence, poor pleadings, and poor production of documents. So the role, your role in this adversarial system is very important, because all of you are future lawyers and many of you will be joining courts, or you will have to come across the litigation system in our country. So in arbitration, the difference between courts and arbitration is parties decide that there is an agreement in writing saying that parties will have the matter decided by an arbitrator. And I'll just be dealing with that in a moment. As opposed to the adversarial system, we have amicable ways of dispute resolution, and they involve negotiation, mediation, and conciliation. So now today we will be talking of the other systems, that is the alternate dispute redressal systems, namely arbitration, negotiation, mediation, and conciliation, very briefly. And then we will be talking about the career options and how you should go about each thing. I will very briefly talk about these, and I would very much like if you all have you all interact as much as you possibly can. See, here we have the parties choosing arbitration, and there is an option to decide for a private dispute resolution procedure instead of going to court. Under the New York Convention, which India is one of the earliest signatories, once there is an agreement to enter into arbitration, the courts are required to refer the parties to arbitration. And if you look even at the Arbitration Act, Section 8, it says clearly that the courts or judicial proceedings shall be referred to arbitration. The general principles are that the object of arbitration is to obtain a fair resolution of disputes by impartial third party. So if some of you are thinking of how will I become an arbitrator and what is required, there are certain specific skills and qualities required. And one of them is neutrality. Then the second point is that parties should be free to agree on how they are resolved, how the disputes are to be resolved. And this is based on the principle of party autonomy. And once the matter is decided by an arbitrator, or once the matter is referred to arbitration, the interference by courts is very minimal. And unlike an appeal in a civil suit, which you would file an appeal against an order of a civil decree, the appeal against an award, which is actually objections under Section 34 of the Arbitration Act, the scope is very narrow. There are very few grounds in which the court can interfere. And therefore, this principle of minimal interference by courts is a principle that guides arbitration. So the neutrality of the arbitrator, the party autonomy, and minimal interference by courts are some of the principles that guides arbitration globally, including in India. So arbitration is consensual, like I said, and the parties choose the arbitrators, or they give a option of whom to choose from, and the arbitration is neutral, which is as is required in courts. One of the key advantages in commercial matters is that confidentiality of the proceedings is maintained, and this would help especially when there are trade, commercial, and business and proprietary rights that are being decided. Then the arbitral award is final, and it can be enforced as a decree of the court. We do have domestic arbitration, we have international commercial arbitration. All these are defined in the Arbitration and Consolidation Act, Indian Arbitration and Consolidation Act. And there are some globally acknowledged principles, which you will find in the New York Convention and UNCITRAL rules. And those are also very important aspects that you'll have to look at. Institutional arbitration, we can talk of institutions such as in India, we have the Indian Council of Arbitration, we have the Nani Palkiwala arbitration. The ICC is in Paris. The Singapore arbitrations are also very, very well known. Singapore and London and New York arbitrations in international arbitrations. So, and there are some very well established institutions. These institutions have an advantage. Institutional arbitration does have an advantage because the rules of procedure are as set out in the guidelines, and also they have certain benchmark for who an arbitrator will be, and they have a panel roster arbitrators. So the importance of institutional arbitration is one aspect that you will also have to consider. International arbitration, like I briefly said, is when one of the parties is international or outside India. And I will not go too much into detail in this since we are fairly short on time. Okay, we're talking about a career option. See, to be an arbitrator, a lot of work is required to go into it. It's not like once you enroll as a lawyer, you can immediately become an arbitrator. I did mention about institutions. Many institutions have certifications which train arbitrators or train people to become arbitrators. And there is much knowledge that is required to be developed by each student. Firstly, you'll have to know what is dispute resolution. And if you were to ask me for advice on this, I would say that the young lawyer should spend some time in courts and learn the entire judicial process, how the civil procedure works, how the commercial courts function. Of course, you need to know what is the Arbitration Act in its entirety, and understand. I did mention about the adversarial process. Understand how courts function, because to know what is alternate dispute resolution, you have to first fully understand what is dispute resolution and how it functions. And this is something you can't read, read a book about. You have to have practical and first-hand knowledge, and knowledge of the laws, knowledge of procedure, etc. is required. And if you look at institutions like the Chartered Institute of Arbitrators, UK, or the Singapore Institute of Arbitrators, to become empaneled as an arbitrator, you require to reach a certain level of qualification. And to attain that, there's a requirement of number of years of practice. There's a requirement of passing certain exams. For example, if you're talking of Singapore Institute and other institutes, you have the level of associate member. The next higher would be fellow, and then something like chartered arbitrator. And a chartered arbitrator or a fellow are highly experienced arbitrators who have actually performed arbitrations and rendered a good number of awards. So to get into this field of arbitration, you will need to first learn litigation. You will need to join certain association, develop certification, and assist in various arbitrations. Join an office of, for example, an arbitration counsel or an arbitration lawyer or a law firm, and understand how it works. Because many arbitrations, the amount of groundwork that is required, for example, if it's a construction arbitration or a simple commercial contract, there is a certain level of evidence that is required. And when you prepare your statement of claim, as you know, the procedure would be generally procedure in a civil suit. You're required to file a plaint. You're required to, then there's a written statement filed by the opposite party, followed by documents, admission, denial of documents, affidavits of evidence, then cross-examination of witness. And I think just before that, you would also frame the issues, then go into evidence and trial, and then finally argue and dispose of the matter, decide the matter. So a similar, most arbitrations in India and globally follow similar procedures. So sometimes parties agree on different types of arbitration. For example, you can have an arbitration which is or a documents only arbitration, and parties want to decide the matter in a short period of time. So these are all aspects that you can get exposed to only by practically seeing it on the ground. Another aspect of ADR is negotiation, and this is something that all of us are accustomed to. In fact, we negotiate all the time. Many of our conversations involve negotiation. So it is done right from your childhood, done with your father, with your professor, with your colleagues. So it is a process of consensual bargaining, and it is generally it involves party autonomy, and parties themselves engage in discussions. So it is a way of finding an agreement to end a dispute. So just to quickly go through the negotiation, we talk of there's a mutual endeavor to resolve disputes, and negotiation saves time because there's no involvement of courts, lawyers, or any third parties at this stage, and parties can decide to maintain compromise, maintain confidentiality, and there is generally a compromise. And parties can also be creative in finding solutions. And this, I don't think for this, for today, we will go into this, except to say that there are two types of negotiation. One is distributive and there's integrative negotiation. Here, I'll just like to point on two aspects. One is the Batna. You should know what is your Batna, what is your Vatna, and what is the Malatna. And these are important aspects one needs to dwell on. And it is very similar to mediation. These are the similar principles that are used in mediation as well. So, for example, if the negotiation is, if the litigation you think will take 5 years, so that is an aspect you must consider. Also, litigation is going to cost $200,000 per year, and will appeals further delay the process? Will litigation damage the relationships? Will litigation damage reputation? Will litigation go on beyond generations? Because I've done many cases where suit was filed by somebody and then his children were brought on record, and sometimes even the children were no more, and then it went on to the next generation. So is it really a factor? I mean, is it really worth putting a number of generations through? We'll go quickly to mediation, and mediation is a process where there is a external third party who's a neutral, and it'll be worth reading what Mr. Sriram Panchu says. Mediation is a process in which the mediator is an external person who's neutral to the dispute, works with the parties to find a solution which is acceptable to all the parties. One of the key features that you must remember is mediator is a facilitator. He only facilitates. Unlike an arbitrator, he doesn't decide, doesn't adjudicate. And mediator enables communication and negotiation between the parties, encourages the parties to participate, and the parties will themselves find solutions. So these are some key aspects of mediation. Conciliation is also a voluntary process where the parties involved are free to agree and attempt to solve their disputes through conciliation. It is a flexible process and allows the parties to define the time, structure, and content of the proceedings. And these are rarely in public. They are interest-based, as the conciliator will when proposing a settlement, not only take into account the parties' legal positions, but also their commercial and financial or personal interests. So I think I will quickly conclude, because by leaving it to you all for questions.
Hello, sir. Thank you so much for that really insightful session, sir. I'll just proceed with the first question, which was on the YouTube chat box with regards to the
I'm not able to hear your. Okay, I'll see the chat box myself.
mandatory arbitration proceedings in India, sir. And what is your take?
Diksha, I'm not able to hear you clearly at all.
Hello, sir. Can you hear me now?
I can hear you, yes.
Yes, sir. So the first question is in regards to the mandatory arbitration proceedings in India, sir. And what is
Okay.
your take on it?
What is mandatory arbitration?
Yes, sir.
Okay, I think what I understand is there a situation where parties can be forced to go into arbitration?
No, sir, I think it's a general question because I think you mentioned in the course of your speech that arbitration most likely has to be consensual in nature, but there are also certain situations where the court requests for a mandatory arbitration. So how does that work out, sir?
Well, if you go according to the UNCITRAL rules, New York Convention and the Indian Arbitration Act, one of the key aspects of arbitration, established principles, is that it is consensual, and one of the most important aspects is party autonomy. Not only the parties have the autonomy to decide who will arbitrate, they can also decide on the procedure, the venue, the seat. So any agreement which is one-sided and makes it mandatory on or makes it obligatory on the other side to arbitrate without their consent, then it won't stand the test of the Arbitration Act and the basic principles of party autonomy. So that being answered, I think your question is, in case there's an agreement where parties sign the agreement, then can they be forced to go to arbitration? But if the parties sign of their own volition, then I think they'll have to be asked to arbitrate. They can't resile or renege from that. But there's no such thing as mandatory arbitration. I'm not able to understand the question because at least I tried my best to answer it. I hope it answers your question.
Yes, sir. Thank you. Sir, also could you slightly highlight in regards to the enforcement of foreign awards in India?
Well, foreign awards can be enforced under, I mean, foreign awards can be, New York Convention awards and Geneva Convention awards are enforced under the Arbitration Act. And the requirement is that unlike section 34, where there are objections, the the person, the decree holder or the person who holds the award will have to show that the award was passed by following the principles of section 48.
Thank you, sir. So moving towards a question in regards to the how to actually build a career in arbitration, would you suggest to first work with an arbitrator, or how do you suggest one proceeds?
First is, like I said, it's most important to get to know what is the process, litigation process, dispute resolution process. So exposure and understanding of the entire process is most important. And one must, I think the best way in India is to work with a litigating lawyer. Litigating who does litigation as well as arbitration. Because when you are filing a claim, you will need to examine a host of documents, and you will need to prepare. You need to weigh the evidence and see which document works best for you. You should have to understand what is the claim, the basis of the claim, the law that is the basis of the claim, which section of the Contract Act or any other act, and then the terms of the agreement, how they are to be interpreted. So this preparation requires a lot of work, and to be at a level where you can understand how to draw up a claim, you need to understand the entire process, how courts look at various sections of the relevant acts, whether it's a tender, whether it's a contract, it's a construction agreement. So without that exposure to the litigation process, I think it will be difficult for an arbitrator to get to understand, for a lawyer to get to understand the arbitration process.
Thank you, sir. Sir, speaking in regards with litigation and arbitration, what would you say are the key benefits of preferring arbitration over litigation for students who are pursuing litigation or dispute resolution as a career option?
For students, I'm sure if you look at litigation versus arbitration, litigation could take more time, and in India it is more expensive, but in other countries sometimes arbitration is more expensive. The best thing about arbitration in India is the time limit to pass the award. So you are bound to do it within, the arbitrator is bound to do it within 12 months. So that is a very attractive feature of dispute resolution. So if you can get your matter decided within 12 months, and you know that the scope of challenge under Section 34 is limited, then I think you would prefer. I mean, as a litigant, you would prefer arbitration over litigation. As a young lawyer, the movement, the work in arbitration is a lot, and since things move so fast, you would require to be very sharp, and your ability to learn and get exposure to various aspects is a lot faster than in courts. For example, a young lawyer who wants to practice on the original side would require to have an exposure to trial. Trial would include evidence, documents, understanding documents, the value, weight of each document, and how its evidence is to be read, and also preparation of your examination in chief, which is nowadays done by affidavits, and preparation of cross-examination, which if you were to be in a civil court, sometimes it takes a long time. There are times when it takes long for a party, for a case to reach to the stage of cross-examination. However, in arbitration, you're bound to see it within 6-7 months after the arbitration commences because of the timeline. So that is an advantage.
Right, sir. So also there is one question on the chat box, which is, what are the key points to be added when drafting an arbitration clause? Often we see, often we have seen every word in clause argued at length. Could you share any highlights from your career in relation to this?
Arbitration clause is something that has to be drafted very, very carefully. And first of all, it has to say what are the disputes to be arbitrated. It has to talk about the seat, the venue, the procedural law, the law applicable to the agreement, and the various these are some of the key aspects. So all of these aspects have to be taken into consideration, and while drafting the arbitration agreement. However, one point that you must take note of is there are certain institutions which have standard clauses which have been taken care of, have taken care of all the aspects like seat, venue, law, applicable law, procedural law. So the advantage of institutional arbitration will give some clarity to the parties of how the procedure is to be followed when the arbitration goes on, and what are the steps to be taken. For example, if you have the Indian Council of Arbitration, there's a registrar who would look into various aspects of the process, etc., and issue notice in a particular manner. Then there are already timelines set for various aspects in addition to the Arbitration Act. So there may be certain timelines for filing of documents, filing of claim, response, etc. So the advantage of having a clause from an institution and following an institutional arbitration is definitely there, because institutions also have infrastructure and they run very smoothly. The disadvantage of not being clear about venue, seat, and procedure sometimes can lead to complications. And if the arbitrator doesn't follow those, follow the steps, the principles and procedures as set out under the Arbitration and Consolidation Act, then there's a liability for it to be disturbed in the objection process under the Section 34 of the Arbitration Act.
Thank you, sir. I also, so you touched upon in your talk in regards to international arbitration. Could you also highlight the ways in which students can enhance their chances in international arbitration?
Okay. See, to get into the field of arbitration, I think it will be useful to be associated with various organizations. For example, if a student aspires to have an international practice, he or she should look at how institutions such as the Hong Kong institution, HKIAC, Singapore, SIAC, ICC in Paris, or London, LCIA, how they function, and get to work closely with lawyers who are practicing in these areas and these particular aspects. And also, there are some soft laws, like laws for ICC, for admission of evidence, for what are the documents, the Prague Convention on electronic evidence, etc. So there are various soft laws that one would should also get exposed to, which are used mostly internationally. So exposure, like I said at the outset, is the key to building up expertise in this area. So I think a person who's aspiring for working in the international field should look into that direction and find lawyers, find law firms, etc., who are working there, and go and associate themselves, and also join associations. Like, for example, Charter of Arbitrator has student membership, which is free. Get involved, see if you can find some lawyers in the international practice there. There are young arbitrator groups, I think in LCIA, if I'm not mistaken, which some of you can consider. So look for associations and be there with those who are experts in this field. So that's the only way to learn.
Thank you, sir. Sir, could you also brief in regards to the skills that students need to develop to become arbitrators in future?
See, if you look at the Arbitration Act, I think there's a certain amount of time required to be an arbitrator. It's probably 10 years. And if you look at SIAC guidelines, I think to get onto the roster of arbitrators of SIAC, you need to pass certain awards, or you need to also have a fellowship of Singapore Institute of Arbitrators. So if you just look at the fellowship of Singapore Institute of Arbitrators, it requires knowledge of how you examine a statement of claim, how you examine documents, how you look at documents, how you weigh evidence, and how you examine evidence in chief and in cross-examination. And then most of all, the ability to write an enforceable award. And to write an enforceable award, one requires a good amount of experience, because there are certain requirements there in the Arbitration Acts and in UNCITRAL rules, etc. However, to practically learn this, you will have to be thoroughly ingrained in understanding what is an enforceable award, what can be set aside, for example, if a person in a statement of claim does not ask for interest, and the arbitrator feels that interest should have been granted, even though there's no prayer, he grants the award of interest, then that is liable to be set aside under Section 34, because the arbitrator, the parties didn't ask for it, and the arbitrator had no business in passing such an award, which was not claimed for, and he could not apply his own mind to do that. So all this comes by experience, and to understand all of this, I think level of diligence is required. You'll have to be thorough in your drafting, thorough in reading the papers, thorough in knowing where the documents are, and the law, of course, you'll have to know. So it requires a great amount of diligence.
Thank you so much, sir. And I think we just have time for one more question. So since right now emergency arbitration is in the news quite a bit with regards to the Amazon and Future case, could you just brief a little bit about the emergency arbitration provisions in India?
Well, we have the word emergency arbitrator is not mentioned under the Indian law, but the Amazon judgment recognized the award of the Singapore arbitrator, thereby, which was the Delhi High Court said first that it's that the emergency arbitrators award is a good award, and this was upheld by Justice Nariman later. But arbitrators have the power to pass interim measures, and so, and if it has to be passed under, say, section 17, though the term is not used, and our law does accept the principle of emergency arbitrators, though it has come up for the first time in this decision sometime last year, I think, by the Supreme Court. So emergency arbitrators, according to the latest Supreme Court ruling, is there to stay, yes.
Thank you so much, sir. I think with this, we have come to an end for the webinar today. Thank you for answering all the questions which were posted both on YouTube as well as on the Zoom chat box. I now request Andrew to just deliver the formal vote of thanks.
At the outset, on behalf of the management and students of the St. Joseph's College of Law, I would like to express my heartfelt gratitude towards Mr. Robin David for taking time out of his schedule to interact and address us on the career opportunities and alternative dispute resolution. I am sure our students have much to gain from the discussion today. We also thank our director and principal for the support in organizing the webinar today. Thank you all. Have a great day.
Thank you.